A lot of employees are afraid to complain about problems at work. I can't tell you how many calls we get where we ask the employee, well, did you complain? Did you make a written complaint? And the response is, no, I didn't want to lose my job. No, I didn't want this to affect my employment. This is my livelihood. And so they didn't make complaints. They just stayed quiet. And then ultimately, something adverse did happen. Ultimately, they may have gotten terminated, but it was too late. They never made that initial complaint. So oftentimes, employees are afraid to complain about maybe a disagreement with a coworker, whether it's they feel like they're being harassed or maybe subjected to a hostile work environment or micromanaged. And sometimes it's not actual harassment, but they're worried to complain. It could even be sexual harassment where the employee is worried to go to their boss and complain because they may be afraid that they'll be retaliated against if they do make a complaint of harassment in the workplace. Typically, employees complain about feeling harassed in the workplace or bullied, or they may complain about safety hazards. Maybe they feel like they're working in an unsafe work environment. We see this a lot with drivers where the tires on trucks might be bald, or they are operating vehicles that they feel like are not up to date, up to keep, and may be dangerous when they're driving long distances for their workplace. So we see complaints about health and safety, what they feel is health and safety violations, harassment. And then sometimes employees complain about wage and hour violations where they feel that they're not getting their sick days that they're entitled to, or they may not be getting their appropriate rest breaks. So if they make a complaint, then oftentimes that employee feels like, well, if I complain, am I going to get retaliated against? Am I going to get fired? Am I going to lose my job? But I think the biggest one, the most concerning complaint that employees sometimes stifle and keep back is the sexual harassment allegations, where they're subjected to maybe it's touching, groping, crude comments, offensive comments, and they're really worried because they're excelling in the workplace. They're doing great. They're getting great performance evaluations and reviews, yet if they complain about a boss or another supervisor or another coworker harassing them, then maybe that will limit where they can promote in the company, or maybe they'll be fired because of it. And so they keep it quiet and they keep it down so that they can excel in the workplace instead. California is an at-will employment state, which in a few words, it means that an employer can terminate an employee with or without cause. But what we're looking for as employment law attorneys is, did the employer terminate the employee because of retaliatory motives or discriminatory motives? So we're looking for that ill intent, that motive that may be unlawful. At-will employment does not mean that an employer can fire an employee for absolutely anything. There are protected activities which prevent an employer from firing an employee. For example, if an employee makes a complaint regarding what they reasonably believe is unlawful conduct, an employer cannot retaliate against that employee and fire them for that complaint. That would be illegal. If an employee discloses that they feel like they are a victim of harassment or discrimination in the workplace, an employer cannot fire that employee simply because that employee made that complaint. If there's a causal connection between the complaint and then the termination, that would probably be illegal. It would be a wrongful termination claim in California. Reporting illegal activity and then being fired for that could result in a wrongful termination case. So if an employee feels that they are reasonably reporting what they feel is illegal conduct, and in response to that, the employer terminates them, that could be a wrongful termination case in California. Illegal firings in California, despite the at-will state, would be firing an employee because they reported to HR or their management that they were being sexually harassed, or fire an employee because the employee went to the employer and said, I think our practices might be illegal. We might be engaging in some sort of fraud. Or an employee goes to an employer and says, I think I'm entitled to sick days and you're not giving them to me. And in response, that employer fires that employee. That would be illegal termination, wrongful termination in California. So if an employee reasonably believes that they are being subjected to unlawful conduct and they report that, then they may be protected from a termination. So there's a wide variety of complaints that an employee can make because they may think, oh, this is illegal. I reported it and in response, I get fired. So they may think this is a wrongful termination case. So what we're looking for is an employee going in and making a complaint that there is harassment or that their boss is simply not accommodating them. They are subjected to unsafe conditions. Maybe they're climbing ladders. The warehouse is excessively hot. They don't have any drinking water. Those types of complaints may be protected from a termination in California. Complaints to HR are not necessarily protected under California law, but a complaint about harassment or discrimination or illegal conduct or unsafe working conditions, that would be a protected activity, a protected complaint. That may be protected under California law. If an employee makes a complaint about unpaid overtime or wage and hour violations, they are protected. That's protected activity. And so if an employer terminates an employee because they made this complaint, that would be liability for the employer. Workplace retaliation is when an employee engages in protected activity. They go to HR or their manager and they make a complaint. And they reasonably believe that they're making a complaint about unlawful workplace conduct. And in response to that, the employer terminates that employee. That would be retaliation in violation of California whistleblower statute violations. Common signs that an employer is retaliating against an employee could be a demotion. They lose their shifts. Their schedule's now completely changed. Their job duties are being stripped away. They're subjected now to excessive scrutiny or disciplinary action immediately following their complaint. Or the easiest to notice is a termination. That would be retaliation. Retaliation does not always mean an employee has been fired. An employee who has been demoted or isolated, excessively scrutinized, disciplined, or a decrease in their wages, those could all signal adverse action, which is what we're looking for in retaliation cases. Employers can retaliate against an employee by terminating them, by demoting them, by being so aggressive and hostile and demeaning and isolating that employee to the point of trying to force them out. So that could lead to a constructive wrongful termination case, which is a violation as well. If an employee is worrying about being fired for making a complaint, they should start documenting everything, including taking daily notes. Journal what you're experiencing. You should also document your complaint when you send it into your either HR or your manager or your boss. Make sure it's in writing. If it's not in writing, it didn't happen. That's what the employer is going to argue. So I say document everything, put it in an email, and then also keep your own notes. A daily log will show what you experienced in that time period, and that helps us if we move this case forward. Evidence that can help prove retaliation are written complaints. So documented complaints that are sent to HR or management, also text messages, notes, journals, anything written during that time period is really going to support the claims that because an employee made a complaint, they were then subjected to retaliation. Mistakes an employee can make after reporting a workplace issue is, one, saying it instead of writing it. So one big mistake is that an employee goes to their boss or their manager or HR and verbally says their complaint, as opposed to writing it down, sending an email. We want the written paper trail. And so that could be a huge mistake when we're trying to navigate through a case. One mistake I see employees making after they make a complaint regarding workplace issues is quitting, letting the employer win, walking away, and not seeing what happens from there. Maybe the employer does the right thing and fixes that workplace issue. Or maybe the employer does the wrong thing and fires that employee. But we need the employer to respond, because without the employer's response, we're limited on what we can do for the employee to advocate for them from there. Employees should avoid getting aggressive or starting altercations because they're upset about a workplace issue. Maybe it's cussing, getting angry, starting a fight Avoid the altercation. If you want to make a complaint, make a complaint, but do it in a professional manner so that you don't become the issue in the workplace, so that you aren't the one to blame when the employer makes a decision regarding your employment. Be professional. That's the best thing an employee can do in that situation. An employee should consider talking to an employment law attorney if they feel something's going wrong. If they feel like they are a victim of some workplace issue that may be actionable, call an attorney, ask questions, at least see if you're protected, or get guidance on what you should do next. Sometimes employees don't know that they should document a complaint. An employment law attorney may say, put your complaint in writing. This will help you in case your employer fires you. It's good to speak to an attorney before being fired because you want to make sure you're taking the appropriate steps to create your paper trails, to make sure that you are documenting your complaints and communicating with the employer in the appropriate manner. But sometimes employees don't have that option. And so their only choice is to contact an employment law attorney after they've been terminated. If an employee has an actionable wrongful termination case or retaliation case, then an employment law attorney can help them navigate through that matter. They will retain them as a client and take them through the litigation process and hold the employer accountable for what they did for the retaliation. Many employees are scared to speak up at work, and I would want them to know that you have a voice. You can make a complaint and be protected, but it starts with you. You have to speak up and you have to say it. Otherwise, you're not doing yourself anything to better the workplace, and you're not doing your employer any favors by not speaking up about what you feel is wrong in the workplace. You have a voice, use it.